Many thanks, yes. Indeed, my name is Jonathan Bosso. I'm a PhD candidate at Paris 1 Panthéon-Sorbonne. And this is the topic of my presentation today, the rules on the service of process of a foreign state. Next slide, please. First of all, why does service matter? Well, you might have seen in the news recently that in the wake of Russia's recent aggression of Ukraine, many Western states have frozen the funds of Russia on their territories. And we don't know yet what these states will do with those funds, whether they will be permanently seized, like France has suggested it would do with the assets of Russian oligarchs, or whether perhaps other states will choose to lift the immunity of execution of those assets and then thereby make them available for judgment creditors. Now, it's very important for creditors that service be made properly because it will enable them to get their award recognized as a judgment of the jurisdiction. And most importantly, this in turn will enable them to set the date at which the debt arose in the jurisdiction and the order of priority between judgment and creditor. So we might see a little bit of a rush of competing lawsuits, and service is very important to know who is going to be first in line. Service is a very technical topic, so I won't get into all the details, and there will be, I'll refer you to the chapter for that. But if you have one thing to remember from my presentation, it is this: the rules on service are very confusing. These rules enable foreign states to significantly delay proceedings against them. And all of this could be avoided if creditors or arbitration practitioners suggested to their clients that when they sign contracts with states to include service waiver provisions. So my presentation has three parts. I'll go over the rules, the obstacles to service, and then some solution to those obstacles. What is the purpose of service? Well, in domestic jurisdiction, it's the same purpose. You want to alert You want to alert the defendant that proceedings against it are underway, and if the defendant does not respond to the judicial documents or appear to get to offer the plaintiff the opportunity to get a default judgment. Well, when serving private litigants abroad, all states have very specific rules and additional requirements to serve defendants, and they have even more requirements when serving foreign states, and this is the topic of my presentation. Now, I suggest that the goal of those rules on the service of process on foreign states is twofold. First it is to enable these slow bureaucratic entities to respond to foreign suits, but perhaps more importantly, it is to enable them, it's because we're dealing with sovereign equals here. So sovereign equals of the foreign states where proceedings are brought. So therefore, consideration of state immunity, committee, and potential reciprocity apply. Let me give you an example of service rule. These rules are typically found in state immunity laws or in special provisions of civil procedure codes. This is the example of the US. So in the US, there's 4 methods to serve foreign states, which are listed in hierarchical order. So first, you need to serve the state according to any special agreements or contract that you have with the state, if there's any. If there's none, then according to the applicable International Convention on Service. And this includes the 1965 Hague Service Convention, a multilateral treaty that facilitates service to defendants abroad, a point I'll come back to in just a little bit. If there's no international convention applicable, then through a mail requiring signed receipt. If signed receipt is not received, then, and if all else fails, then through diplomatic channels. And, but at the same time, states have very different rules on serving foreign states. States like the UK and France use diplomatic channels unless there's another agreement, and other states like Argentina, for instance, have no special rules on service. Just to give you a sense of what diplomatic channel is, it's a very complicated process which starts in the state of the jurisdiction where the proceedings are brought. So typically you would serve on your Ministry of Foreign Affairs, or on your Ministry of Justice, who would serve it on the Ministry of Foreign Affairs in your country, who would then forward it to the local embassy of in the foreign country, who would then forward it to the Ministry of Foreign Affairs, Ministry of Justice. So that you can see it's a very long chain, and I'll come back to some of these where the chain might break in a little bit. So the obstacles, I suggest that there are two obstacles, two categories, and I'll give a few examples for each, but just in the time allotted, I'll focus on a few, and there's many more in the chapter, unfortunately. The Hague Service Convention. First problem, does it apply to the service to foreign states? It was meant to apply to service to private litigants, and it does not say whether it applies to foreign states. As I've mentioned, in the US, courts have constantly found that it does apply, and the basis of this is because in the convention it is specified that it applies in all civil and commercial cases, so there's no really limits there. But other states, like France for instance, have, or the courts in France had constantly found that it did not apply to service to foreign states, and that French law, for instance, was applicable. But this was until a 2019 decision of the French Cour de Cassation, where the first time the court found that the other agreements in the French law includes the Hague Service Convention. So in that sense, service through diplomatic channels was not required. But because service through diplomatic channels could be made under the convention as well, it applied. So it seems like a little bit of a circular reasoning. At the same time, it is consequential because the convention lists methods of service, but it also has other requirements like translation or lack thereof. So, and these would apply obviously if the convention applies, and which would not be the case if service was made solely pursuant to domestic law. And the convention is very complicated, very technical, poorly drafted document that is confusing to all. So for instance, in the United States, when lawyers found that option number 2, service to the convention, is not possible, they're typically very happy to go to number 3, which is sign receipt, much more straightforward. But even for states that are party to the convention that still do not believe that it applies to service to foreign states, like the UK, ascertaining the content of service rules is very not straightforward still. And a good example of that is a decision from last summer of the UK Supreme Court. And in that case, the point of uncertainty, I've tried to break it down here because it's a very technical question, was whether, because the civil procedure rules do not require an award creditor to serve the award debtor with a form instituting the enforcement proceeding, the requirement in section 12.1 of the State Immunity Act to serve any writ required to be served for instituting proceeding against a foreign state was applicable. In that case, it mattered very much because at the time of service, Libya was in the throes of a civil war, and if you remember the chain I told you about, the British embassy in Libya was closed, which meant that service was effectively impossible. And there were two governments, and it was a very complicated thing. But by a very slim margin, a 3-2 margin, the UK Supreme Court found that the service through diplomatic channels was mandatory and exclusive, that there was no way around it, despite the exceptional circumstances in that case, that it applied to any documents relating to foreign states, basically. We get here to the second point I want to make regarding the obstacles, is the applications of the rules. Here's how we could summarize service in France. It's slow, it's complicated, it can take a few months, it can take a few years. And it's a very opaque process. What you don't get when you try to serve a foreign state is a little UPS update of where the process is going at each step of the way. Next slide, please. What you get is this. Basically nothing. Next slide, please. And at the same time, creditors have always been apprehensive that service through diplomatic channels was tainted by political consideration on the part of the forum state, so the state where the proceedings are brought, that perhaps the state was trying to delay the proceedings. And what we learned in general dynamics was a very surprising thing, the fact that the FCDO, the UK's Ministry of Foreign Affairs, follows a political, unwritten, unlegislated process to serve, which it was summarized in that case in this way. So basically, if the UK Ministry of Foreign Affairs find that there's a visit, there's an election, there's a potential visit of a ministry, then we don't serve. We don't want to get into the trouble with the other state. And the fact, I'll summarize the situation for you, is whether that is correct or not, we don't know, because judicial review of this process is not available, basically. Long delays, and as lawyers' favorite saying goes, justice delayed is justice denied. But that's not all. At the same time, while awaiting service, judgment award creditors are afforded little to no protection, so for that 6 month, year, 2 years, because there's no availability of interim measures against state assets meanwhile. And there's a real risk that during this time the state might try to dissipate its assets in the jurisdiction. So the question that arose from all these obstacles is whether the rules on the service of process of a foreign state comply with the creditor's right to fair trial under human rights law and constitutional law. And Lord Jones, for writing for the majority in general dynamics, said, well, this case was too special. The civil war in Libya was too special, and there's no reason to impugn the entire procedure because of that. At the same time, the year before, we'd found that the FCDO, again the Ministry of Foreign Affairs, had lost the diplomatic bag and could not find it in a case against Egypt. In a case the year before, we found out that because Iran's Ministry of Foreign Affairs, against in the chain, all the way up to the end of the chain, had refused to receive service, and service was not made properly. So it's not so clear whether these circumstances are so exceptional. Now, what solutions are there to those problems? And I'll offer a few. One is to try to serve the state through multiple methods when they exist and when they're available under domestic law. So you might try, for instance, if you're in France, to serve through diplomatic channels, so to send it to the Ministry of Justice, who will then start the chain. But you might as well serve it to the lawyer who represented the state in the arbitration. You might as well serve it through through mail requiring signed receipt. And the result of this is that the state might accept service, the state might appear and not contest service, or the courts might find that the alternative method of service was valid. But the most prudent practitioners would suggest, as I've mentioned in my introduction, would suggest to state to the private litigants or private parties that they represent to try to include a service waiver provision in the contract that they sign with state and state entities. And best case scenario is what I've included on the slide. A broad sovereign immunity waiver, service of process provision, submission to court jurisdiction, and waiver of prejudgment and post-judgment attachment. That might not be possible in all cases because the state might fight it back, but it might not fight back the service provision, because this will seem like a very straightforward thing, and I suggest that it would be very wise to include that in the contract with the state. And then I suggest two options. So the first is to designate in the contract a registered agent. So if you are contracting with France and you want to, you know that France has a lot of assets in the US, and then you want to say perhaps that you might bring try to recognize an award against France in the US, you might want to designate a registered agent, so a lawyer of France in the US that you could serve to directly, in which case it would enable you not to serve abroad, and it would be much simpler. And then also include a service waiver provision. I'm working on one for the chapter, which I hope to include. So I'd be very keen to discuss with you what this clause should contain, but it's very technical and complicated. For states, I suggest that similar types of waivers should be included, perhaps that state in investment treaties. Perhaps states will not want to include broad or sovereign immunity waivers in their investment treaty, but I suggest that service waivers should be included. And the fact now is that all investment treaties, at least that I know of, do not address questions of immunity or execution or enforcement of awards. And there's perhaps many reasons for that. One is perhaps that treaty negotiators don't know or care very much about the execution or enforcement of the award, but you would have listened to my presentation very carefully, and you will not be in that category anymore. And then the question is, why would states want to include that in their investment treaties? Well, my point is that states who do pay and consistently pay their investment awards would want to see the state, their co-contracting party, to do the same. So that's an argument. But we've also seen very recently in investment treaties all these provisions to help small and medium enterprises to do investment arbitration. Well, now if you're trying to enforce an award against a state that's less than 10 million, good luck, because it will be very expensive. So circumventing the problems on service that I've mentioned would save a lot of cost, but also it would depoliticize the dispute, and perhaps most importantly, it will afford the foreign investor, well, at least it would bring the foreign investor one step closer to getting the full reparation that the investment treaty was supposed to afford it in the first place. Thank you very much.